good morning, good afternoon, good evening. I hope you're all doing well this fine Friday. Anybody got the Friday feeling yet? Excuse me. All right, we're talking Kohberger today because there has been an absolute ton of new information that's come out in the pre-trial filings on both sides, state and defence. There's like a little war on words going on, as there always is. When it gets to this point in a case, the pre-trial stuff is incredibly important. If you're following a case, really following a case, then all the pre-trial stuff is as important as the information that's presented at trial. I guess you would say, no, it isn't, because at the trial, the jury's sitting there. The jury determines the facts and issues their verdict accordingly. But all the pre-trial stuff decides on what the jury's going to hear. And as we've seen in the Delphi case, because in that case there was so much not allowed to be presented to the jury, in my humble opinion, that case is not a fair. It's not fair. It's not fair. It's not a fair trial. So the pre-trial stuff, really important. And what we're going to do today is we're going to go through some of the recent court filings. I'm not going to be reading them all word for word, or else we'll be here about 12 hours. I'm going to be picking like certain points and giving you my opinion on them. Just my humble opinion. So we've got some stuff from the state, we've got some stuff from the defence. Most of these are motion in limine, so this is for the judge to order on as to whether certain pieces of information are going to make it into trial or not. What is admissible in court in front of the jury. So motions in limine are very, very important. Now, it doesn't look like the judge has ruled on any of these. I don't know whether they're just going to have a whole hearing on it. I don't know. But we're going to go through them. And I think the big thing that's doing the rounds at the moment, both on mainstream media and on social media, is relating to the DNA under the fingernails. So under Maddie's fingernails, there was DNA. That's done the rounds over the last few days. But honestly, it's one of the least interesting things to me. There's stuff in these filings that are really interesting. So let's take a look at them all. I'm going to say a couple of hellos first, though, give people a chance to come in. I am a little bit early starting this live stream, I think probably for most people. But you can always watch it on the replay. I'm not going to go too long. I've got stuff to do later, so I've got a maximum of 2 hours. I can always do a part 2 if we end up chatting too much about one topic and we end up not finishing what I want to get through. We can always do a part 2. So there's no worries on that front. All right, who have we got in the house? We've got Azzy TV. We've got We Are Dust, Linda. Cameras in court at trial? I assume so. All the pre-trial hearings have been televised. Now, way back, both sides, state and defence, tried to get Judge John Judge, the previous judge, to get rid of cameras in the courtroom. Both sides wanted rid of cameras in the courtroom for the pre-trial hearings. And Judge Judge said no, he wanted cameras in the courtroom. So Judge Hippler seems very, very open. He wants everything to be transparent. Like, I stopped looking at all the filings because there was so much that was being sealed. It got tedious. There was too much that was sealed. But Judge Hippler has said that there is too much in this case that has been sealed, and he wants stuff, unless it's, really necessary, he wants stuff to be out there in the public domain. So that leads me to believe that Judge Hippler isn't gonna preclude cameras. There are certain times when they will need to for the pre-trial stuff, like the IGG was done like behind closed doors, but then Judge Hippler released the transcript of that hearing with only a few minor redactions. So he does seem to be very open and transparent, and there hasn't been any call to have cameras excluded from the courtroom at trial. So I'm assuming it's all good so far. Hello, Twisted, Leah, Bobby. Made it through the week. Yet again, we made it through another week. Hello, CW and Queen of Ravens, certainly Gail from South Carolina, Em Osland, Leslie. Oh, I always have chats on during live streams. I don't think I've ever done a live stream without a live chat. It is possible. You can turn chat off, but I've never done that. I've never seen a reason to do that. Hello, Jadzia, Rocket Queen. We've got Reese Corp, Down Under with Love. I guess it's a good time for those Down Under. It's like kind of going to be late evening, is it, for most of you there? Bear You Babe. We've got Sassy, Momo Shark, Barbie. Good morning, good afternoon, good evening to you. Mandy, Stephen, Brambriel, Lisa, Amy. All right. Enough. Excuse me. All right, let's make this a little bit bigger. And we're going to go through a whole bunch of these filings. I really like the way this is set out. They've changed it a little bit from last time I was here. Maybe, possibly. I don't know. But I like it. You can tell exactly what you're clicking on. I love it. And we're going to start with Alibi. And again, I'm not going to be reading all of these filings. If you want to read them all, then the link to this website here is in the description box. You don't even need a VPN or anything like that. Doesn't matter where you are. I'm in the UK and I can get this without using a VPN. So they're all easy to get. I'm going to start with the Alibi. And this is from a while ago, but I'm starting on the 21st. I'm kind of starting on the back end of where Judge Hippler left off with his orders that he made regarding what the hearings were about recently. So IGG and that stuff. I read all that. I read his orders in, was it 2 previous live streams that I did on that? So I'm starting kind of on the back end of that. And we're just going to work our way up this docket. And again, not reading them all. I'm not even going to click on them all. But I do want to acknowledge a whole bunch of these things. Again, this is really important because this sets the scene for what we're going to see at trial. And more importantly than what we're going to see, what the jury's going to see at trial. All right, Alibi. Now, this is from the state. And they want, I love this. They want Brian Kohberger's alibi gone, unless he actually presents it himself. Now, they've said that they've waited a long time for this, to hear his alibi. Is it blurry or is it just you? I think it's just you, but you can possibly correct it. It's possible that your settings are dodgy. So if you click on settings, like the little cog, and you go to quality, you can increase your quality. Now, it will only give you up to 720p because that's what StreamYard will give you. But if it's anything under 720p, then increase it to 2720. to 720p, and it should de-blur it. Otherwise, just go out, click out, and come back in, and it may just write itself. 480 is fine for reading this. Mine's on 720, and mine's as clear as a bell over on my other screen. So I can see what you can see over on my other screen, and I've got it set to 720, and it's fine. So, all right. So there's been a lot of talk, not recently, about the alibi. So this is a motion in limine to prohibit the defendant from presenting any evidence, whether direct, by direct or cross-examination, in support of any claimed alibi, other than from the defendant himself. Now, look, I don't understand how he can, or anybody can present Brian Kohberger's alibi other than himself. Because his alibi has been, I don't know whether they've got it here. This is just a big list of everything that has been talked about in the court filings. So where does it start about stargazing? Maybe it doesn't. Maybe it doesn't. But his alibi is that he likes to go driving at night and he likes to stargaze. So he goes to like a park, a national park, a little bit south of Pullman, Washington. He goes there to stargaze, where it's really, really dark at night. So perfect for stargazing. However, that particular park that they mentioned in a previous filing is closed at night. Now, it doesn't mean to say that you can't just park up, like on the side of the road near the park, and stargaze. I mean, look, all you have to do to stargaze is look up. And on a clear night, they're all there, right? So, you know, does he have binoculars? Does he take a telescope with him? Or does he just use the naked eye and browses the stars, has a look at the constellations, and he watches them moving across the sky? What is he doing when he's stargazing? Well, there's nobody else. Like, he's on his own. So how on earth is he ever going to be able to present any evidence of this alibi other than from his own words? I don't know. So for these reasons, the court should issue an order prohibiting defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. So look, I think he should just be allowed to present whatever evidence he sees fit, honestly. If he can provide evidence, or someone else can verify that that's where he was at the time of the murders, then let them. So if I was the judge, I'm just giving you my opinion here, if I was the judge, I'd say, no, denied. State, no. The defendant can present anything he wants relating to his alibi. Let the jury hear it all. But again, I'm not the judge. This is all just my opinion. All right, the next thing I want to talk about is alternative perpetrators. So this is another one from the state. And again, if I was the judge, I'd deny this personally. So the state want to prohibit the defense from offering alternative perpetrator evidence. No, I think they should be allowed to. As long as there's a, let's use Judge Gould's word here, a nexus. As long as there's a nexus, you're not just randomly naming people, who have absolutely no connection to the case at all, if you can provide evidence to suggest that there are alternate perpetrators, then I think the jury should hear that. And look, I personally believe that they've got their man. I personally believe Kohberger did it. Let's put it this way. I haven't seen any evidence that's strong enough to give me a reason to believe otherwise. However, I'm very open. I'm not wedded to that. I'm not convict Kohberger, and that's it. No. I want to hear all the evidence. I want to hear it all. I want to see it all. So I would deny this. Would I deny it without a hearing? No. I'd want the defense to tell me, look, this is just the state. This is just the state saying that they don't want the defense to present any alternate perpetrators. But we don't know whether the defense is even going to offer that as a defense yet. So both sides, what both sides are doing, this really is a war on words. What both sides are doing is trying to preempt what the other side might do. Now, maybe they have backroom chats. Maybe each side does know where the other side is going to go, you know, with the next round of filings, and they're trying to preempt stuff. Well, okay, if you're trying to preempt stuff, it might well be that the defense isn't going to offer an alternate perpetrator. They're not going to go down that road. And if so, this is a moot point. But I wouldn't want to be denying any of this without a hearing. I'd want to hear it all. If I was a judge, I'd want to hear it all. There are some, actually, coming up that I might decide to deny without hearing. But generally, if I was a judge, I'd want to hear it all. Like Judge Bev's doing in the Karen Reid case. You know, Judge Bev is very biased. She's very biased. She's very pro-prosecution. But at least she hears it all. She hears both sides. She gives both sides a fair shake. I'd be like Judge Bev. Be like Judge Bev. Don't be totally one-sided like Judge Bev, but allow the sides to speak like Judge Bev, not like Judge Gull. Nothing Judge Gull has done, ever, is what I would do if I was the judge. So let's just take a little shimmy at this. All right, so moves the court in limine for an order prohibiting the defendant from offering an alternate perpetrator evidence argument without first satisfying the court that any such evidence is relevant and admissible. Well, that's fine. That's fine. You can't just come along and start naming people. You've got to have your nexus. So I agree that, of course, the defense should, if this is the way that they want to defend their client by offering up alternate perpetrators, there has to be a reason why those alternate perpetrators are in the firing line. You can't just randomly name people. It's the probative value of the proffered evidence. Well, that's up to the judge to decide initially, but ultimately, if there's a nexus, even if there's a little tantalizing clue, let the jury hear it. I don't agree with what they say down here. Here we go, this paragraph. In this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement. With the exception of information regarding the defendant, none of these tips were substantiated. The state submits that any attempt by the defendant to offer or argue an alternate perpetrator theory without evidence specifically connecting persons other than the defendant to the homicides would do nothing other than mislead and confuse the jury and would result in undue delay, waste of time, and would be a needless presentation of cumulative evidence and unfairly prejudice the state. Under Idaho Supreme Court ruling, this should be prohibited. Again, I'd want to hear if the defence is preparing an alternate perpetrator defence for Brian Kohberger. As a judge, I would want to hear it all first. So I will be listening to this very carefully, and potentially I'd deny the state's request if there is some form of evidence that the defence could muster. I would deny this. I'd want the jury to hear it. All right, you thought I was going to be all pro-state, didn't you? No, I'm not. I'm not all pro-state. Just because I personally haven't seen any evidence against Brian Kohberger being the guy doesn't mean to say I don't want to see any potential evidence that there might be. No. All right. Now, let's get into something really interesting. Brian Kohberger's mental health. Now, a little while ago, recently, maybe last week, the mainstream media and some social media I saw also discussing Brian Kohberger's autism. Now, were you surprised that Brian Kohberger has been diagnosed with autism? I'm not surprised in any way, shape or form that Brian Kohberger has been diagnosed with autistic spectrum disorder. The traffic stop that has been released of Brian, cop stopped him. This was when he first moved to Washington. A cop stopped him for doing something, I don't know what he'd done at an intersection. And he wasn't arguing. He was very polite, but he was like, he wasn't even being a smart ass, honestly. But he was really trying to understand this rule because it's not the same in Pennsylvania. And I thought, yeah, you're on the spectrum. You're definitely on the spectrum. Now, this is how it gets interesting, because both sides are trying to use this diagnosis for their own purposes. And honestly, I don't believe it's relevant. Personally, I don't believe. No, look, I don't know Brian Kohberger, never met Brian Kohberger. I'm not privy to the psych evaluation or the neurological evidence that I'm sure both sides have got in their possession relating to Brian Kohberger's diagnosis. I'm not privy to that. But I'm just saying what I see here. That Brian Kohberger is a very capable individual, okay? At the time of his arrest, he was a PhD student studying criminal justice. So he's gone through a bachelor's, he's gone through a master's, and he's been accepted onto a PhD program. So his intelligence is not in question, okay? So his autism doesn't present with any learning disability, right? Some people on the spectrum have learning disabilities. They're nonverbal. They're so profoundly disabled that they are disconnected with the world. You know, autism is a huge spectrum, huge. You know, on one side, you've got somebody who is very learning deficient, somebody who cannot connect with the world in any meaningful way, you know, from an outsider's perspective. You know, that they can't speak, that they need maybe technology or a special assistance to be able to communicate. That's not Brian Kohberger. Brian Kohberger is way over on the other side of that spectrum, right? He's highly functional. You know, he can drive. He was living alone. He highly educated. There is nothing to suggest that Brian Kohberger, that his life has been has been prohibited in any meaningful way due to his autism. Now, look, you're going to say, Michelle, you don't understand autism if that's what you're saying. Yes, I do. I understand autism. I understand that just because Brian Kohberger's highly intelligent, just because he can drive a car, just because he can run his own life, he can live alone, he can do this, he can do that, doesn't mean to say that he doesn't have deficits in other ways. Yes, right? He might have problems with social skills. It might have problems with certain types of, like maybe like understanding nonverbal cues, stuff like that, right? The reason why I don't think in this instance Kohberger's autism is relevant is because it isn't relevant to him committing a quadruple murder, if indeed Brian Kohberger did it. Autism didn't cause Brian Kohberger to commit a quadruple murder. It didn't influence the way he got caught. So how is even bringing up Brian Kohberger's autism relevant in this case? I'm not saying that the jury shouldn't know that he's autistic. I'm just saying, why is it relevant? And both sides seem to be preempting the other here. Like there's a whole series of filings. And I'm going to go in chronological order, although it kind of actually makes sense me talking about the defense first, but I'm not, because I'm going in chronological order, and it was the state who filed first. On the 21st of February, they filed this. Very short. Very short. So the state of Idaho respectfully moves the court for an order in limine prohibiting defendant from offering testimony regarding neuropsychological evaluation and psychiatric evaluation of the defendant. So they don't want it mentioned. They don't want his autism mentioned, which on the face of it, as I've just said, I agree with, because it's not relevant. However, let's read on. In support of this motion, the state respectfully refers the court to Idaho Code 18, blah, 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 which provides that mental condition shall not be a defense to any charge of criminal conduct, except expert evidence on the issues of any state of mind which is an element of the offence. So any condition. So look, autism isn't a mental health condition. It's a neurodivergent condition. It's got a neurological basis, but it can and often does create mental health challenges. So they're saying that, look, it doesn't matter. It doesn't matter what this dude has. It doesn't matter what condition he's got. It's not relevant unless it's related specifically to something to do with the offence. So it would be my request, if I was the judge, to say to the defence, well, how do you think Brian Kohberger's autism is relevant to this case at all? How is it relevant? Because the defence have written a lot about Brian's autism, as we'll see. So we've got some defence exhibits here, which I can't find. I don't think we can see them. But each of the witness summaries, defendants exhibit D7 and D13, the defendant specifically states the testimony is not intended to be a mental element defence pursuant to Idaho Code 18207, but rather this testimony is about the state of mind as well as factual defence testimony as anticipated testimony elicited by the state. Okay. Well, because I don't know that we've got these, it's difficult to understand what this means. So are the defense going to offer that Brian's state of mind was problematic at the time of the murders? And as well as a factual defense testimony to anticipate it. So to defend what the state might come up with in relation to Brian's mental health. Neither side should be mentioning Brian's mental health, his autism, or any other diagnosis unless it's directly relevant to something to do with the murders. Now, in my opinion, the defense is talking themselves into a corner by pursuing this. Because if they're going to try and argue that Brian's state of mind at the time of the murders is relevant to this case, what does that tell you? What does that tell you? It tells you that they think Brian did it. Because if you're using a defense of mental ill health, or you're using a defense of, you know, some kind of condition is, you know, the state of mind you're in at the time of the murders, yeah, you're going to try and mitigate, maybe trying to mitigate, but in mitigating, if you are not guilty, if you did not do it, if you absolutely did not do it, there's nothing to mitigate, is there? Because you didn't do it. But by offering mental health or autism as a mitigating factor, you're almost going down the road of an insanity defense, although they're not, because he's not insane, but you're along those lines. You see where I'm going with that? Do you see where I'm going with that? If you're defending your client as someone who is completely and totally factually innocent, and your defense is that you're going to counter under cross-examination everything that the prosecution has got in evidence against your client, and maybe you're going to offer your own witnesses to bolster your defense, that's great. You believe your client is factually innocent, and that's the defense you're going to use. My client is innocent, and here's why. Now, of course, the defense doesn't have to offer any witnesses. They don't even have to do anything, right? Because it's not their burden. It's the state's burden to prove that Kohberger did it. It's not the defense's burden to prove that he didn't. However, if you're absolutely defending your client as one that is factually innocent, using mental health as a potential mitigating factor is way risky, because a juror is going to say, hold on a minute. If you're saying that Brian Kohberger during the murders had a problematic state of mind, you are admitting you did it. Interesting. I'm going to show you. I'm going to show you this one. So we're going kind of a little bit out of order. So don't need to do that. All right, autism, we've got two. We've got autism spectrum disorder, and then we've got conditions as an aggravator. Both of them, these are defense motions, both of them that were posted to the court on the same day, the 24th. Okay. This one is like a psychology essay, 28 pages, that reads like a psychology essay. I don't think we need to read it, although if you want to, you can do it. It's just a lot of it is about autism itself. All right. So what you need to understand is how the defense are planning to use this information. If you want to go and read about autism, please feel free. But I'm not going to read through 28 pages because I understand autism. If you need to understand autism better, then go and read what the defense has written, like in the psychology essay. But this is in relation to the death penalty. All right. So Brian Kohberger, by and through his attorneys of record, hereby moves this court to strike the death penalty as a sentencing option in his case because Mr. Kohberger's autism spectrum disorder reduces his culpability, negates the retributive and deterrent purposes of capital punishment, and exposes him to an unacceptable risk that he will be wrongfully convicted and sentenced to death. By making this motion, Mr. Kohberger relies on his right to be free from cruel and unusual punishment, his right to due process, his right to a fair trial, his right to counsel, his right to present a defence, his right to a reliable sentencing determination, and other rights safeguarded by the 5th, 6th, 8th, and 14th Amendment to the United States Constitution. Listen. No. Brian's autism, right? Brian's autism does nothing. Again, he's highly intelligent, very capable, right? He's capable of being highly educated, driving a vehicle, moving across state, living on his own. All of those things he can do. So why is Brian's autism relevant to things like due process, his right to a fair trial, his right to counsel, his right to present a defence? How is Brian's autism relevant to any of that? It's not, is it? It's not, is it? Now, they're trying to argue. I have read this. Like I said, I'm not going to read it, but if you want to, please do. But just these section headings. Are you not going to read the defense doc? I'm going to read the next one, which is along the same lines. But I'm going to just show you these section headers just to show you where the defense are going with this. Due to impairments in communication, reasoning, social skills, impulse control, people with ASD are insufficiently culpable to be executed. Maybe someone with ASD who is at the very, very severe end, who is completely learning deficient, who can't understand the world, yeah, they have reduced culpability to anything that they might do to harm other people. They have reduced culpability, just like anybody else who has a very severe brain disorder, like someone with advanced dementia. You can't say that they're culpable of any harm that they cause because they don't understand. Somebody who is psychotic, they're not culpable either. Unless you judge Gull and you will allow the quote-unquote confession from a psychotic man in as evidence, but unless you're her, then somebody who is in psychosis is not culpable. Somebody who is very, very young is not culpable because they don't understand, right? But someone who has got ASD, just the diagnosis of ASD, just the diagnosis of ASD does not reduce someone's culpability to a crime that they have committed. The deterrent and reproducible, I can't say it, aims of the death penalty are not met by executing people with ASD. Now, to me, look, I'm not going to get into whether I think that people with autism should be executed or not, except to say, no, somebody who is highly dysfunctional shouldn't be executed. But somebody who is highly functional, it's not relevant. They understand what they did. They understand why they did it. They understand law. They absolutely understand law. They understand punishment. But no, I don't agree with this at all whatsoever. I don't agree with this. Really do not agree with this. So if I was the judge, I would say, no, denied. Denied, if I was the judge. Now, this next one, this is really interesting. Conditions as aggravator. So this was posted on the same day that the death penalty thing that we've just looked at was posted. But it's about autism. It's just taking it from a different angle. So I'm going to read this one, 7 pages. I find this one really interesting. So Brian C. Kohberger, bound through his attorneys of record, hereby moves the court for an order preventing the state. So again, this is the war on words. This is the defense here wants to prevent the state from doing this, from using Mr. Kohberger's mental health diagnosis of autism and the characteristics of his autism as evidence in this case. Now, we've just seen that was 3 days previous. We've just seen the state actually commenting on Brian's mental health. We've just looked at this document here. And what the state said is that they wanted an order prohibiting the defendant from offering testimony regarding neuropsychological evaluation and psychiatric evaluation of the defendant. They didn't want to talk about it. They don't want to bring it up because they don't think it's relevant. Because his mental health condition, from the state's perspective, is that it doesn't matter. It's not a defense. It's not a defense. You can't use it. You're not insane. It's not specifically, it's not your state of mind related to your condition that created the murder. So, no, it's not relevant. But then, 3 days later, the defense produces this. That they don't want the state to bring it up. They don't want the state to bring it up. Well, great then. Both sides are agreed. Both sides seem to be agreed. Let's not talk about Brian's mental health. The state don't want to bring it up because they don't believe it's relevant to the murders. And now the defense are saying they don't want to bring it up. Well, they don't want the state to bring it up because it's not an aggravator. They aren't saying he's insane. Exactly my point. Thank you, Need Some Z's. Absolutely. They are not saying he's insane. To make a claim of reduced culpability, they have to say that you are so deficient in your learning ability, your understanding of the world, your understanding of rules. You are that deficient that you are, legally, you could be classed as insane. No, they're not saying that. Absolutely, they're not saying that. And for that reason, Brian Kohberger's mental health is not relevant to the murders. It's not relevant to the murders. And as such, As such, it shouldn't preclude him from getting the death penalty. Do we know when he was diagnosed? I don't know if it gives a date. Anyway, we're going to read all of this because this is interesting and it is only 7 pages. So, okay, so they want to prevent the state from using Mr. Kohberger's mental health diagnosis of autism and the characteristics of his autism as evidence in this case. This motion is meant to protect Mr. Kohberger's 5th, 6th, 14th Amendment rights under the United States Constitution and Article 1, Section 6 and 13 of the Idaho Constitution. Mr. Kohberger has a diagnosis of autism and he displays characteristics consistent with autism. A comprehensive neuropsychological evaluation of Mr. Kohberger conducted by Dr. Rachel Orr, PsyD, IBPPC, I don't know what that is, found that Mr. Kohberger continues to exhibit all the core diagnostic features of ASD, currently with significant impact on his daily life. Okay? So he's got significant impacts on his daily life, according to Dr. Rachel Orr. Who is she? Let's have a look at her. I haven't looked her up. I don't know her. Rachel. Let me spell Rachel right. Good grief. Rachel Orr. we've got we've got a Rachel Orr who does high heels. I assume this is her. So she's British. Maybe there's more than one Rachel Orr. Seems to be like quite a few Rachel Orrs. Oh well, don't want to get the wrong one. I don't want to get the wrong one, so let's move on. Mr. Kohberger shares characteristics such as social challenges, perseverance and perseverance. Does that say persevere? Yeah, it does. And lack of reciprocity. So he can't share. He's not good at sharing. These characteristics are noted by those unfamiliar with autism as not picking up on social cues. Okay. So just because you don't pick up on some social cues doesn't mean to say that you don't understand the law. He understands how to drive, so he understands the rules of the road. So you understand that murder is wrong. That's the bottom line. That's the absolute bottom line. Someone who is so impaired in their understanding of the world that they do not understand rules such as killing is wrong, those are the kinds of people who have reduced culpability. Not somebody who has problems understanding social cues. Okay, all right. In evaluating Mr. Kohberger, Dr. Orr found that he has displayed lifelong deficits in social emotional reciprocity, including limited perspective taking. Again, you might not be able to understand someone else's perspective, like you think your perspective is better than everybody else's. However, you still understand that murdering is wrong. Okay. And limited sharing of affections, emotions of others. You can lack every piece of empathy there is and still understand that murdering is wrong. Because of his autism, others may see Brian as not recognising social cues, continuing to talk to others when the conversation will naturally end, over focusing on a topic or hobby of interest, or talking about the same topic repeatedly using a complicated vocabulary or seeming self-absorbed. Brian's autism is also accompanied by obsessive compulsiveness and an eating disorder. Well, we've heard all about that. All right, so sorting out your trash with gloves on, you could say it's obsessive compulsive, or you could say it's to stop the feds from finding your DNA in the bins. You could say that. Since childhood, Mr. Kohberger has exhibited compulsions around getting things in his eyes, hand washing, and other germ avoidant behaviours. Oh, I bet he hates jail. Oh dear. Bless him. These characteristics must not be used by the prosecution as factors for the jury to consider as aggravators. Absolutely they shouldn't. Absolutely shouldn't. I completely agree. No. None of these things are aggravators. So I agree with the defence here, absolutely. These are not aggravating factors. None of them are aggravating factors. Neither are they mitigating factors. So I completely agree with the defence here that these characteristics must not be used by the prosecution as factors for the jury to consider as aggravators. But if you're saying that the state can't use Brian's quirks as aggravators, then you, my dear defence, cannot use them as mitigators. Because if they're not important enough to be used as aggravators, then also they're not important enough to use as mitigators. So saying about how impaired Brian is, and therefore he can't get the death penalty, quite frankly, by that sentence alone, you have negated everything you've said in that 28-page document, in my humble opinion. You can't have it one way yourself and then expect something else from the other party. I absolutely agree that Brian's mental health, his autism, don't need to be brought up. Don't even need to be mentioned at the trial because they're not relevant to this case. So I agree that the state should not bring these hand washing things up or whatever as an aggravators. How would they be aggravators to a murder? Exactly. You can't use it as a shield, and you can't use it as anything. You can't use it as anything. If you're saying the state, and I absolutely agree that the state shouldn't use these things as aggravators, you cannot then turn around and say Brian Kohberger is so impaired that these things, reduce his culpability. by saying they reduce his culpability, you're admitting he did it. But you can't use them as mitigators to get him off the death penalty. I'm sorry, you can't. If you want to do that, then it's free reign. And I don't believe anybody, including Brian, would be benefited by making this trial about Brian Kohberger's autism. At last count, I think it was something like 1 in 68 people either has a diagnosis or could get a diagnosis of autism spectrum disorder. That's how common it is. You don't see 1 in 68 people going committing quadruple murders or any murders. In fact, people with autism tend to be really big on rules, like following rules. Not everybody, but a lot of people with autism are real sticklers for the rules. They really hate it when people break the rules. Well, one rule is, thou must not kill. That's a rule. So, yeah, there's that. Evidence of mental illness in capital case litigation. is mitigation evidence. No. You can't say, in my humble opinion, if I was a judge, I would say you cannot say that you can't use these as aggravators and then wish to use the very same condition as a mitigator. No. If I was Judge Hippler, I'd put a stop to that. I would cut them down. No. I agree, I would say. I agree with you that you cannot use this relatively mild, let's say, diagnosis of autism. It's relative, it's on the mild end, because he's highly functional, as an aggravator. State, you cannot use these as aggravators, but you, defense, cannot use them as mitigators. All right, moving on. The United States Supreme Court and the Idaho Supreme Court recognizes evidence of a defendant's mental illness as mitigating. But yet you don't want the state to use these things as aggravators. Okay, well, you're completely contradicting yourself. And by going down this road, trying to get Brian classified as seriously mentally ill and so profoundly autistic that they don't understand anything, you're admitting he did it. You're admitting he did it and pleading to the court for mitigation. So in my view, this is a very dangerous road for the defense to go down. It really is. All right, I can skip through this law here. All right. So listen to this. All right. Penry and Lama, maybe, acknowledges the belief long held by society that defendants who commit criminal acts that are attributable to disadvantaged backgrounds or to emotional and mental problems may be less culpable than defendants who have no such excuse. Mic drop. You have admitted Brian did it. You have, and thinking you're clever, you have admitted by that very paragraph that Brian did it. You have used a source. To back up what you're trying to get from a source where they discuss defendants who commit criminal acts that are attributable to disadvantaged backgrounds or emotional and mental problems may be less culpable than defendants who have no such excuse. Mr. Kohberger's autism is a mitigation evidence. It's mitigation evidence. You've admitted he did it. Or at least you believe he did it. You've admitted it. You've admitted it in black and white. I'm sorry. I'm done. I'm done. This is laughable from this point on. It's inappropriate for the prosecution to wrap mitigating evidence into an aggravator. There's no question that they were going to, but again, this is about preempting what the other side might try to do. In Roper versus Simmons, the Supreme Court noted with disapproval that the prosecutor had argued that mitigating evidence for the defendant's youth should actually be considered an aggravator. The court suggested that a rule prohibiting such conduct would have been warranted if not for the court's larger concerns requiring that death be excluded altogether. So, defendant's youth depends how young they are. If they're old enough to know what they're doing is wrong, then I'm sorry, treat them as an adult. I'm harsh, me, honestly. Allowing the state to argue that Mr. Kohberger's mental illness is an aggravating factor that violates the 8th and 14th Amendments by precluding the jury from giving meaningful consideration and effect to mitigating evidence. Again, I don't think the state, if they were going to do, no, Michelle, defendants can use all sorts of arguments in front of a judge so they cover all bases. This is not an admission of guilt. Put it in front of a jury, and I think a jury would disagree with you. Okay. All right. Again, I don't think the state should be using mental health as an aggravator. Likewise, I don't think the defence should be using it as a mitigator, because he's not seriously mentally deficient. He understands right from wrong. He understands the rules of the road. He drove from Washington to Pennsylvania. He literally drove across the entirety of the United States. Yes, he had a couple of traffic stops, but he wasn't, he understands the rules of the road. If you understand the rules of the road, you also understand that thou must not kill. Okay. So it goes on about mitigating factors. All right, so we've got some law here. I'm not going to read all that. So allowing the state to argue that Mr. Kohberger's mental health issues are actually aggravators unlawfully interferes with the jury's ability to give effect to that mitigation evidence. Listen, if the defence really wants to argue this point, then let the jury hear all this mitigation evidence. Let them hear it. Let them hear it. Because I think a jury, if you're trying to mitigate, they're going to say, what are they mitigating? Like, if he was innocent, there's nothing to mitigate. They go down the road that I've gone down. They go down the road I've gone down. When you're mitigating something has happened that you need to mitigate. There's no need to mitigate when something didn't happen. So, yeah, put it in front of the jury. And it sounds like it's not just the judge, as the previous comment said, it's not just the judge that they're arguing against to cover all bases. No, they want to put this in front of the jury. I think that would be an incredibly bad idea for Kohberger, for the reasons I've just stated. It's obvious. Incredibly bad idea. But hey, look, if they're that keen on it, let's hear it. Let's hear it. It's more prejudicial than if the sentencer were told to ignore it or give it no weight, which is prohibited by law. The state also cannot argue that factors which are causally related to Mr. Kohberger's mental health issues should serve as an aggravate or serve to aggravate the punishment. That they contribute to future dangerousness, propensity to kill, or contribute to aggravators regarding heinousness of the crime. Well, no, I don't think that the state should be, nor maybe would, argue in front of the jury that if you let him go, he'll do it again because he's dangerous. No, I don't think the state should be arguing those kind of things. I think that is prejudicial. But I assume that the state wouldn't go down that road. And if they did, the judge wouldn't allow it, because that is highly prejudicial. But again, these are all preemptive war of words. Preemptive war of words. All right. I don't think we really need to read much more. Allowing the state to argue that Mr. Kohberger's mental health and developmental disabilities are aggravators violates the 8th and 14th Amendment, criminalising his state as a disabled person. All right. He's not that disabled, though, is he? No. Okay. All right, moving on. I thought that was really interesting. And it's one that is, I don't think there's one right answer here. I'm going to be very interested in seeing how Judge Hippler handles that. Very interested in that. All right, let's move on. Let's move on to some of these more silly ones. Some of these are silly. All right. we've done autism. We've done that one. All right, make and model. So all these, there's a big long line of these. So we're going to click through some of these. So make and model of vehicle. So this is relating to the Elantra. I don't actually think I've read this one. So exclude trial testimony by any state witness as to the make and model of the vehicle seen on 1112 King Road surveillance footage. No, absolutely not. No way. If I was the judge, I would deny this. I would read the first sentence and I would deny it. No. The vehicles that are seen, or people that are seen on surveillance cameras next door to the murder house, absolutely should be shown to the jury. Some of these filings from the defense here smack of desperation. I understand why they're doing it. I understand why they're doing it. Don't come at me saying he's entitled to a defense. Of course he is. And they're entitled to try every single possible thing to, sway the jury in their favor. They're only doing their job. I don't blame them for it. I'm very glad Brian Kohberger is getting a rigorous defense. Absolutely. They're trying really hard for him. But no, if I was Judge Hippler, I would say no. Absolutely no way. You know, the autism one, it's complex. There's some complex things to think about there. But this is a straightforward no. No. That you can't mention the make and model of the vehicle seen on 1112 King Road. So it's next door to the murder house. To say that you can't mention the make and model of that car is insane to me. Insane. All right. Let's take a look. This court is required, to the extent possible, to limit a jury's exposure to inadmissible evidence. The state has claimed in various filings and reports that an FBI forensic examiner, Anthony Immel, identified the make and model of this vehicle seen driving in the area of 1122 King Road in the early morning hours of November 13th, 2022. The state has referred to this as suspect vehicle 1. The vehicle was not identified from surveillance footage in the area. Okay. So we've got a screen grab here. Like, this is disingenuous. This is disingenuous. They've used a screenshot in this filing where the lens has blown up this light. Like the camera's like blown up this light. Looks like the vehicle's on fire. I am sure there is an angle. When you watch the video, there is an angle where that full vehicle can be seen. Like when it's driving here, when it's not directly, like its lights blazing into the camera to make it like blow up like that. I'm sure the entire vehicle can be seen. And somebody who has, a knowledge of make and models of cars would be able to give a very good estimate of the make and model of that car. And anything that is seen on surveillance should be shown to the jury, whether it's favourable or not to either party. What are we seeing here? What are we even seeing here? Let me read. Surveillance footage comes from a residence 1112 King Road. Depicts the corner of King and Queen Road Nice with the camera from the footage, lights from the vehicle can be seen. Okay, whatever. Oh, I think it's showing lights. All right. Oh, that's passing by. Yeah, you're showing shots here. You're showing shots here where no, you can't make out the make and model. But disingenuous this. These photos are from the 1112 King Road camera. Special Agent Emil did not make a vehicle identification. Did not make a vehicle identification was not made from this footage. Bad grammar. Rather, as noted in emails between Mr. Emil and FBI Special Agent Edward Jacobson, it's clear that the identification of the make and model of the vehicle in this video was made via a separate video taken at 1125 Ridge Road. Got a great one. Is that your evidence? Got a great one. Okay. Listen. This is a point for cross-examination. This is not, if I was the judge, I would say this is denied, that on direct, the prosecution can ask Special Agent Emil, if they choose even to call him as a witness, they might not even call him as a witness. Again, these are all preemptive filings. But if they do, right, there's no reason that the prosecution can't say, in your opinion, your expert opinion, what is the make and model of the car that passes by on the camera of 1112 King Road? And he's going to say, looks to me like an Elantra. Now, on cross-examination, that's the time when the defense can bring up all of this. Isn't it true, Special Agent Emil, that you did not make a vehicle identification from this footage, and rather it was emails that you exchanged with another special agent whereby the identification was made? And then the special agent then can say, oh yeah, sorry about that. Yeah. So it reduces Special Agent Emil's credibility in the eyes of the jury. But let the jury hear it. Let the jury hear that argument. Don't not put it in front of the jury at all. Make that argument in front of the jury. Let them decide. Because there might be at least one member of the jury who will say, I don't believe that's an Elantra. That doesn't look like an Elantra to me for X and Y reasons. Let the jury decide. That's what they're there for. That's what they're paying them for. The jurors get paid in the United States. When I was a juror, we got expenses. You get like a certain amount per day as expenses. Isn't very much. And you get travel, I think. Travel expenses. There is no continuous footage linking the vehicles at 111 King Road and Ridge Road. Okay, great. Make that point to the jury and let them decide. So I would deny this. I would deny this if I was Judge Hippler, and I would say, these are good points, but these are points for you to make under cross-examination of this witness, should the prosecution decide to call him. All right, moving on. Where were we? All right, down here. All right, I'm going to leave IGG. So the judge has already ruled on this, that IGG is allowed. But there is a little bit later on, the state. Actually, we might as well do it while we're here, because these are all on the same day. We might as well just get this done. It's interesting that Judge Hippler has already ruled that IGG is in. I'm not doing a Franks, it's in. So what the defence wanted to do was get IGG thrown out, and then basically everything that came after IGG is fruit of the poisonous tree, and that basically breaks the state's case against Brian Kohberger. Well, the judges put a stop to that. So, no, IGG stays. Therefore, everything that came from it related to, finding Kohberger and arresting Kohberger is in. But it's interesting here that the state has given a motion in limine here regarding IGG. Interesting. So what they want to do, so this is the state respectfully moving the court to order that describing the extent to which the parties refer at trial to the investigative genetic genealogy used in the case, and 2, excluding from the trial any testimony or evidence related to the United States Department of Justice interim policy on forensic genetic genealogical DNA analysis and searching. That's a very long sentence for a policy. The terms of service of any of the genetic genealogy subscription services, the policy debate. All right, you see what they want. So they want IGG in. They want IGG in, right? Because if IGG was thrown out, then by the fruit of the poisonous tree, the state would have no claim to Kohberger. The case would crumble. But then in the next breath, they come along and say to the judge, we want any mention of the way that IGG was used. We want that banning from the trial. Again, you can't have it both ways. You can't have IGG in and then not talk about those issues in front of the jury. I'm sorry, you can't, in my opinion. So I deny this. I say, no, listen, state, you made a very good argument as to why you used IGG and why we've kept IGG in this trial. You can't now come along and say you don't want mention of how IGG was used to be put in front of the jury. I think the defence does have the right to talk about it if they want to bring it up. Now, maybe I'd say there are some limits to it, but no. There were mistakes made in the development of that IGG. The FBI did use databases that were precluded from, that tell their users that law enforcement aren't going to use their data. And the FBI went against their own policy. Now, as I said in a previous live stream, the FBI didn't do anything illegal. They didn't break the law. It's more of a problem for the private companies that are telling their users not to, that they don't let law enforcement use their data. Because it's clearly not true. Law enforcement can use their data. There's no law against it. They can use their data. But should it be made a massive focus of the trial? No, maybe not. But I don't think I agree with them banning it completely. The state's view from the outset has been that the IGG information was nothing more than a tip and was never intended to prove or substantiate defendant's guilt. Instead, the state planned to rely at trial on the evidence developed after the use of IGG, such as the SDR DNA analysis that found defendant's DNA matched the DNA collected from the K-bar knife sheath. And that is the strong stuff. That's the SDR. It's a direct match between the DNA found on the knife sheath and Brian Kohberger. That's it. That's the bizinger. That's the gotcha. The state also made clear from the beginning that it would need to reference the IGG information at some manner at trial, even if only as a generic tip to help the jury understand how the investigation progressed. The defence, on the other hand, has been all in on presenting IGG at trial. It's now disclosed 2 experts, Leah Larkin and Daniel Helwig, whose sole focus is information related to IGG. The disclosure from Miss Larkin indicates that the defence wants to discuss more than the IGG itself, but also present to the jury information one step further removed, including allegations of the FBI use of IGG in the investigation violated a US Department of Justice policy. Again, I would say, if I was a judge, I would say make that a point for cross-examination. So if the defence bring these genetics experts on, then the state gets the opportunity to cross-examine. And it would be easy to say, well, even though the FBI violated the US Department of Justice policy, is there anything that the FBI did that was illegal, that was inaccurate? They have to say no. Let the jury hear it. I'm all in favour of the jury hearing everything. Unless it's completely prejudicial, unless it's completely irrelevant, let the jury hear it. That's where the big mistake was made at Delphi. Now, look, not a mistake, a very purposeful wrangling of that evidence was done. And now, months after Richard Allen's conviction, there's more people than ever questioning the verdict because it's problematic. The jury heard so little of the actual relevant information. It was precluded from the jury. I don't agree with it. It's nothing to do with the fact that I happen to believe Richard Allen's innocent and I happen to believe that Brian Kohberger's guilty. That is not a factor in my thought process at all. In any case, let the jury hear as much as is out there, as much as is relevant, regardless of anybody's opinion, regardless of the factual innocence or guilt of the person in the dock. Let the jury make their decision based on all of the evidence that's relevant. And let the chips fall as they will. Okay, so the state should be allowed to present IGG, at least as a generic tip, to help the jury understand. Great, cool. All right, agree. It's not to say, however, that such testimony is always relevant and admissible. So basically, what they don't want is the defence to bring up the problems. No, I think no. I would deny that. If I was Judge Hippler, I would deny that. I'd say no. You can discuss that at cross-examination. All right, moving back down here. There's some funny ones. Let's do let's do bushy eyebrows. Oh, this is just how silly this case is getting. The defense wants to stop mention of the bushy eyebrows. This is just plain silly, I have to say. 11 pages of this. 11 pages to stop the state from mentioning bushy eyebrows. So the defense moves this honorable court for an order in limine excluding any reference to bushy eyebrows. More specifically, the defense asserts that Rule 403, 601, and 602 of the Idaho Rules of Evidence bar witness DM, so we know who that is, from using the words bushy eyebrows. I'm sorry. Or identifying Mr. Kohberger in that manner. But no, DM could not identify Brian Kohberger from his mugshot. So if the state get DM on the stand and say, is the man you saw in the house on that night in this courtroom? If so, you know, explain where they're sitting and an item of their clothing. They're not going to ask that because she can't. The reason why she can't is because he was wearing a mask. The person she saw was wearing a mask. So she couldn't identify Brian Kohberger from his mugshot. However, they're not going to ask her the question, could you identify Mr. Kohberger from his bushy eyebrows? He doesn't even have especially bushy eyebrows. He's got normal eyebrows, in my opinion, but maybe because he's got quite a prominent brow, just seeing the top, like, you know, section of his face, like his eyes, maybe it just looked like, you know, just at first glance, just at that split second, that it looked like he had bushy eyebrows rather than it was just quite a prominent brow. But it's not a piece of identifying information that I think the state would want to use. Yeah, he was wearing a mask. Yeah, wearing a ski mask or some kind of mask. So a mask wouldn't. If he was wearing, what he should have done is wore like literally a balaclava that just shows your eyes, and then you might even been able to, you know, not show your eyebrows. So look, some people might say, well, yeah, they're on the bushy side. Other people might say they're not that bushy. So let the jury hear it. Let the jury hear DM and her initial description of the man she saw. Why stop her saying the words bushy eyebrows? And why spend 11 pages talking about it? That's insane. I deny this. I deny this completely and totally outright. I would deny this. The reasons addressed above, Mr. Kohberger respectfully requests this court grant his motion in limine to exclude DM from using the words bushy eyebrows to identify the intruder that she saw, and exclude DM from identifying Mr. Kohberger based on bushy eyebrows. Listen, let her. No, I deny this, because that was the word DM used, bushy eyebrows. So by making her change her testimony in front of the jury is wrong. That was her description of the man she saw. Put that in front of the jury, and it doesn't necessarily mean that the jury are going to jump to Brian Kohberger, because like me, I'm sure there will be some people on the jury who look at Brian Kohberger and say he doesn't really have especially bushy eyebrows. It's normal eyebrows. There might be some members who'll say, yeah, they are on the bushy side. But they're not massively bushy. It's not like the bushiest eyebrows in the world. So this is just silly. This is frivolous. 11 pages. No, I would deny that if I was Judge Hippler. It made me laugh, though, when I looked at that. Okay. Okay. So they want, I'm not going to read this one. They want to preclude, they want to limit the words, the relation to touch DNA, which again is another silly thing. I think they should talk about touch DNA. I think the judge will deny that, and rightly. To stop the state talking about touch DNA, again, it's a point for cross-examination. Inconclusive data. I don't remember this one. Oh, this is DNA. Okay. So, moves the court to limit testimony about the statistical analysis of item Q13.1, fingernail scrapings. Fingernail scrapings. So this has done the rounds over the last couple of days. And there was DNA under Maddie's fingernails that doesn't appear to be Brian Kohberger's. So I'm not really sure why the defense want this excluded, but let's read it and find out. Allowing such testimony would violate Mr. Kohberger's federal and state constitutional rights to due process, a fair trial, effective assistance of counsel, and confrontation of witnesses. This motion is based on 5th, 6th, and 14th Amendments of the United States Constitution, Idaho Constitution, Article 1, Section 13, and Idaho Criminal Rule 16, Idaho Rules of Evidence 102, 104, 701, 702, and 703. The requested limits are made to secure fairness in administration to blah, blah, blah. All right, statement of facts. The grand jury testimony. Now, this doesn't make a great deal of sense to me because there's so many redactions, because this was grand jury testimony. So don't blame me if you don't understand it by the end of this, because I didn't either. Like just reading it because of these redactions. But anyway, in grand jury testimony, Jade Miller testified as to the results of testing done on item Q13.1, a swab of the left fingernail clippings from Maddie. The data consisted of 3-person mixture. 3-person mixture. So presumably one will be Maddie's. But remember, Maddie's been out. Maddie's been out and about that night, right? They went to the corner club. So if Maddie had long nails, and I don't know whether she did, like I have really short nails because I bite mine, right? But I have grown them in the past, and just kind of my lifestyle doesn't bear well for long nails. It's not the kind of lifestyle where long nails are at all useful to me. So I end up growing them for a few weeks and then Kyle's back. I end up growing them for a few weeks and then biting them all off because they end up like really black underneath. So if I died and they did like a fingernail scraping, I'd probably have DNA from about 20 different species under my fingernails. Because you can wash your hands and wash your hands and wash your hands and you still have gunk under your nails. I don't understand how people with long nails keep their nails under their nails clean. You end up having to poke things under your fingers to try to get the dirt out, and it was like it makes my nails sore, so I just bite them all off. But anyway, if you've been out for a night and like, let's say you've been dancing, you know, you've been up close to people, you're going to potentially have DNA under your nails. Long nails don't hold debris as well as short ones in my experience. Oh no, completely the opposite. Completely the opposite. My nails are proper short now, and there's no way that you get anything other than my DNA from my fingernails right now because they're really short. Now, maybe if I didn't wash my hands for a few days, maybe you would then, but no. All right. Okay. So it's not surprising that she had a 3-person mixture under her nails. She could have been dancing with somebody, whatever. All right, she'd been out. Maybe she didn't wash her hands when she got back. She was tired. They got some food from the grub truck. That might, just going to the grub truck might have, you know, got some DNA under her fingernails. So I don't think it's an issue. I don't think it's a problem for the case that there's a 3-person mixture under her left fingernails. But it's equally not a problem. It's not a problem for either party, in my opinion, because if Brian Kohberger's DNA being under her nails, it's not surprising that it wasn't, because Maddie was asleep. As far as we understand it, and this is based on what Steve Gonzalez has said, Maddie was asleep. So Maddie had no time to fight at all. And when you're fighting a knife, it's actually, you have to know exactly what you're doing to fight a knife. You have to, and you have to have a big ounce of luck as well on your side, right? When you're fighting a knife. Like, yes, there are ways you can fight a knife. However, you do have to have some luck on your side as well. And if you're asleep, there's no way you're going to be able to fight a knife attack, right? And what you people tend to do when they're fighting a knife, they try to grab the knife or grab the hand that has the knife. It's like, no, don't do that. Don't do that. Parry the knife. But anyway, so the fact that Brian Kohberger's DNA isn't under their fingernails is of no surprise to me whatsoever. But nor is it a surprise that there's other DNA under their fingernails, or at least one person's fingernails. So it's inconsequential, really. But anyway, the jury might think differently, because, you know, juries do consider DNA evidence as being, yes, it's very important. It's very important evidence. But they tend to give it a lot of weight. The statistic, the likelihood ratio, was calculated assuming that Maddie was a contributor to her own fingernails. I find this interesting from a statistical standpoint. So likelihood ratio is just it's a ratio of the likelihood of something happening. And that's how DNA analysis and DNA, the interpretation of DNA analysis is done. It's through likelihood ratios. So it assumes that Maddie was a contributor to her own fingernails. Well, I would assume that as well, but we don't know because this is redacted, which is annoying. It's understandable as it's grand jury testimony, but it means that we can't really understand what's going on here because of these redactions. So Miller testified that Maddie as follows. The data from that sample was blank, as to Mr. Kohberger. So I think that's inconclusive, because Miller testified that inconclusive means, so it was inconclusive for Kohberger, I think. So we've got the redaction there, but then in the next sentence, Miller testified that inconclusive means. They should have redacted that as well, because Mr. Kohberger's inconclusive to this sample. Okay, interesting. So would that mean that Kohberger was counted in the 3-person mixture or not? Would it be Maddie, 2 other people, and then inconclusive for Kohberger? So that's essentially 4 people. Or would it be Maddie, Kohberger, inconclusive, and then 1 other person? I don't think it, maybe it would matter a lot to the jury. To me, I can understand why there wouldn't be any DNA of Kohberger's underneath her nails. I'd actually be more surprised that there was than there wasn't. Because if there was, then it could mean that Maddie did grab his hand, or grab his, managed to grab him, and maybe she wasn't asleep. maybe she woke up with enough time to know what was going on, and that's really sad. All right, Miller testified inconclusive means. Miller went on to explain that the likelihood ratio for Mr. Kohberger, blank, annoying. So the use of misleading language confuses and misleads the finder of fact and is barred by rules. All right, okay. So expanded beyond the language. What do they want banned? Oh, okay. So they want some extra, right? So the likelihood ratio is a comparison of hypotheses. It's not a statement of identity or probability of identity. I think we're going to see at trial the state try to argue that Brian Kohberger's DNA was under Maddie's fingernails. Or else there'd be no reason why the defense would be arguing this. If it's absolutely, no, if it's zero, no, they wouldn't have put this in. So I think the state are going to argue that there was DNA from Kohberger under Maddie's nails. And that would be bad for the defense. Bad for the defense. So the likelihood ratio is a comparison of hypotheses. It's not a statement of identity or probability of identity. Yeah, but if the likelihood is high, if the likelihood is really high, then you can very safely assume that identity is correct. It simply asks the question, given the data, which hypothesis tests more likely? Okay. For item Q13.1, both hypotheses tested for each individual assumed that Maddie's DNA was present. But of course Maddie's DNA was present. You can't swab under someone's fingernails and not have the person's DNA who you're swabbing in your sample. Of course their DNA is going to be in. Listen. So when a lab generates an LR laid out as above, the hypotheses tested were MM, Maddie, KG. Who's KG? Who's KG? When I see KG, because I read Reddit, I always think Kelsey German. And then I think, wrong case. Oh, Kaylee, of course. Dear God. Kaylee. So, Maddie, Kaylee, and one unknown person. They were sleeping in the same bed. So that makes absolute sense. Maddie, Kaylee, not Kelsey. I look at KG and just think Kelsey German. I've been in Indiana and Delphi for so long. I see Kelsey German. Kaylee. So Maddie, Kaylee, and one unknown person versus Maddie and two unrelated persons. This comparison was done for all of the individuals listed in Report 7, which we don't know what it is, we haven't seen it, and for Mr. Kohberger in Report 26. At the ISP lab, any number greater than 100 is considered a conclusive result, indicating inclusion. Any number less than 0.01 is considered a conclusive result, indicating exclusion. Well, that's clear. That's very clear. Thus, if the likelihood ratio falls between 0.01 and 100, the lab cannot draw any conclusions and the data is reported as inconclusive. Yeah, but if it was 99.9, that wouldn't be inconclusive, would it? And if it was 0.02, that really wouldn't be inconclusive, would it? I mean, I know they have to have a cutoff point somewhere, but if it was 50, then yeah, it's bang in the middle. That's absolutely inconclusive. But in her testimony, Miller did not provide a full context to the analysis. The lab reported a series of likelihood ratios for item 13.1 including a likelihood ratio of 0.399, so very low, for blank. Come on, you've got to give me something here. 0.4, nearly 0.5, so that's very low, for blank. 0.2 for blank and 0.02 for blank. So all of those, all right, because all of these are less than 1. And the top of the scale is 100. So if you're 1, you're very unlikely, aren't you? You're very unlikely. You might have to read it as inconclusive, but it's very unlikely. So I don't know who all these other people are. Are these the other roommates, maybe? There's 4 of them. Like Dylan, Bethany, Xana, Ethan. Don't know. Lab report 7 at 3. Okay. All these individuals sit in the same shoes as Mr. Kohberger, namely that the likelihood ratio is exclusionary, but falls in the range of inconclusive. Well, what was Kohberger's? If Kohberger's is as low as this, then yeah, I'm going to say it's very unlikely not to be his. And that doesn't surprise me. Of interest is that when an LR is calculated for blank, 2 blanks, for blank blank, thus Mr. Kohberger's inconclusive LR is similar to almost every other person for whom an LR was generated, and focuses his inconclusive LR. We don't know. Like, was his really high? Like, was his classed as inconclusive, but like 90? Or was it as low as this? We don't know. We don't have any context. So I don't blame you for not understanding this, because neither do I. Because we can't understand it because there's too many redactions. But anyway, the court should exclude testimony such as blank. More importantly, Mr. Kohberger has disclosed that through further independent laboratory testing, he is eliminated as a contributor to item 13.1. When Mr. Kohberger sought to overturn the grand jury indictment, he argued that Miller's testimony was inadmissible and misleading. The state argued that the testimony was presented to a grand jury as exculpatory and an effort to elicit favourable evidence for Kohberger. The independent lab testing concluded that by the defence to item 13.1 is indeed exculpatory. Fair trial is mandated. All right. I'd say show the jury. But if it's truly excluded, show the jury. It's exculpatory evidence. It is exculpatory. However, it's easily explainable. It's easily explainable that she was asleep, and with knife attacks, you don't generally see DNA under the fingernails. Because what people do is try to grab the knife. That's a bad move. Try to grab the knife. But like I said, my understanding is that Maddie was asleep. All right, I'm only going to do a couple more because I'm almost up to my 2-hour limit, and because I've got stuff to do. But there's 2 that we can do really quickly. This one is a bit silly. Not that I disagree. So the defense wants to exclude the state from using the terms psychopath and sociopath. Well, yeah, why would they use those? Again, this is, preemptive, but why would they use those? It's highly prejudicial language. I absolutely agree that the state should not be using terms like psychopath and sociopath unless he has a diagnosis of psychopathy, and then you're back to your mental health argument as to how relevant is any diagnosis to the actual murders. But a diagnosis of psychopathy isn't even doable under the DSM, because psychopathy doesn't exist as a type of mental disorder in the DSM. So, no, I don't think they should. So I would grant this. I would say, yeah, state, don't use the terms psychopathy and sociopath. Don't use them. They're actually not proper, true psychological terms. Sociopath, definitely not. Psychopath tends to be used synonymously with antisocial personality disorder, but it's not a diagnosis under the DSM, and for that reason, if I was the judge, I would grant this. Okay. All right. Last one I'm going to do, the use of the term murder. Now this, I posted this on Twitter the other day, and some people said, Michelle, I expect better of you for saying that this is silly. What was my tweet? Hold on, I'm going to find my tweet. It was like off the cuff. It was one of those off the cuff tweets. I thought was funny. Here we go. Oh no, it's not that one. Which one is it? Here we go. Oh, come on, Anne. So you want his charges to be read like some creators would on YouTube. Mr. Kohberger, you are charged with 4 counts of first-degree unaliving. But yes, I absolutely can read. And it says, this motion is not seeking a prohibition on the use of the word murder or its variant forms in the charging documents or jury instructions. Yes, I can read. I absolutely can read. Am I still on Twitter? Yes, I post every day on Twitter. Well, nearly every day. So they don't want the charging documents changed because first-degree unaliving does not exist in the Idaho Code of Criminal Thingies. But they don't want the state to use the words murder and murder weapon in relation to Brian Kohberger, which I find, quite frankly, a bit silly, because that's what Kohberger is charged with. I don't think it's prejudicial to use the word murder when you say murder suspect. I also don't think there's anything wrong with referring to the K-bar knife, which was used to unalive, I hate that term, unalive Maddie, Kaylee, Ethan and Xana, as a murder weapon, because that's what it was. So if I was Judge Hippler, I would deny this. I'd have a good chuckle and I would deny it. But we're going to read it anyway. So, moves the court for an order prohibiting the use of the words murder, murderer, murdered, murder weapon, and similar forms of the word murder. Like what? Murderous? Murdering? How many other forms is there? Like, what could you use instead? Kill? Slay? Butcher? Slaughter? I mean, you could use way more prejudicial language than murder. Murder's actually a legal term. So why should you not use a legal term in a murder case where the suspect is charged, the defendant is right there in the room, charged with first-degree murder? I could understand them saying, all right, the state starts talking about, this man here to your left is guilty of slaughtering, brutal butchery. This man here, and pointing at him and being really flamboyant, that becomes like borderline prejudicial. When you get that flamboyant and that, juries react to that. They don't always react favorably to it, though. But using the term murder, a murder weapon, in a murder trial, I think is ridiculous. I honestly do. So people who came into my Twitter saying, Michelle, you should know better. No, this is just silly. Using prejudicial language like you are an absolute sociopath, absolutely don't agree with. As I said to the previous thing, that no, the state shouldn't be using terms like psychopath and sociopath when they're not psychological terms, they're not relevant. It's prejudicial because they're highly emotive. Nor should be using terms like butchery or slaughter, or, you know, it's highly emotive. Let's not use those kind of terms. That's problematic. But when you add a murder trial and you're using the word murder and murder weapon, I don't have a... Why? So if I was Judge Hippler, I would deny this. The motion is not seeking a prohibition, as we said. The motion is made pursuant to... Look, you're not denying Brian Kohberger's constitutional rights if you use the term murder at a murder trial in which he is the defendant charged with 4 counts of first-degree murder. That's just silly. Whether the killings at issue are murder, as alleged committed by Brian Kohberger, or an alternate suspect, is someone still unknown, is the ultimate issue. Each side will present its very argument to the jury. No shit, Sherlock. I'm glad you understand that. It's a matter of fact to be found by the jury. All right, okay. So it's up to the jury to decide whether Brian Kohberger is guilty of murder. But using the term murder to talk about the crime at hand, to me, is not prejudicial when he's charged with it. It's not highly emotive. It's a legal term. It's a legal term. First degree murder. It's a legal term. That's just being, that's, I don't know, political correctness gone mad. I'm sorry. Prosecutor, law enforcement, and medical examiner are viewed with authority and respect by most jurors. When persons with authority speak, lay people tend to believe their statements and conclusions. If the prosecution and or witnesses use the words in its case in chief, it would improperly imply to the jury that the prosecutor or witnesses' belief and opinions that the defendant is guilty of murder. No, doesn't. If you're saying, I believe he, right there, is guilty of murder, that's one thing. But using the terms, you know, in context at a murder trial, what other word could you use? Could you use like homicide? All right, use homicide then, but it means the same thing. In the context, it means the same thing because we're talking about 4 counts of first-degree murder. So I think Judge Hippler will deny this. I'd be very surprised if he grants this. Mr. Kohberger requests an order prohibiting the lawyers and witnesses from using the terms murder, murderer, murdered, murder weapon, and derivative forms of the word murder. Okay. All right, cool. All right. There we are. There's loads more. There's all these as well. 911 call. Oh, I've not talked about the text messages. I've not talked about the text messages. I'm kind of running out of time. The text messages are interesting. But this is 10 pages. All right. I'll just quickly, very quickly, just skim through this one. So this is the state. This is the state. Moving the court for an order in limine, allowing the state to admit the text messages. So the state want to talk about the text messages between DM and BF, so the 2 surviving roommates, regarding their conversation with each other on November 13th, 2022. So again, I don't see any reason why these text messages should be out of bounds. I haven't seen that the defense wants them gone. Hold on. I haven't seen that the defense wants them gone. It might be embedded in one of these I haven't read. But I don't think it is. But no, I absolutely think that the jury should see the text messages. Phone records are discovered on the hard drive, DM phone extraction, provided on April 5th, 2023, states Exhibit 18 from the grand jury record. Testimony of DM and BF was provided to the defence as part of the grand jury. Okay. In general, testimony that is hearsay is excludable at trial. However, there is exceptions to this rule. Well, why would these text messages be hearsay? Oh, maybe what they're getting at here is that if they get someone else to read the text messages, it's classed as hearsay. Like if they got either DM or BF on the stand to get them to read these messages, and it's not hearsay, is it? But maybe what they're trying to preempt is not putting DM and BF on the stand to go through all of these text messages because it opens them up to cross-examination, and maybe they don't want to put them through that. Not that they wouldn't call them as a witness at all. Maybe what they're getting at here is maybe they want a law enforcement official to come up and read these messages into the record. Maybe. I don't know. But maybe that's what they're getting at. Again, all of this is preemptive. We don't know what the other side's going to say or do. And we don't really know at this stage why the state is putting this in. So, in general, testimony is hearsay is excludable at trial. However, there are exceptions to this rule. Two firmly rooted exceptions are present sense impression, a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. Excited utterance. So an excited utterance isn't hearsay, is it not? All right, a statement relating to a startling event or condition made while the declarant was under the state of excitement as his cause. Is that really an exclusion to hearsay? No way. Okay, I'll believe you. I'm not going to read the law, but I believe you. So let's have a look at these text messages. So they basically want to be able to include these text messages as exclusions to hearsay. But if either DM or BF read them into the record, they wouldn't be hearsay because it was them that was writing it. So it wouldn't be hearsay, would it? But perhaps, as I said, maybe the state don't want DM and BF to be put through that, and they want someone else to read them in the record. So they're preempting the possibility of the defense saying objection, hearsay at the trial. They want to make sure that these can be included as exceptions to the hearsay rule. So this is going to be interesting as to what Judge Hippler says here. I don't know how he's going to go. I don't know. I think they should allow these text messages in and let someone else read them. Or sometimes they just give the whole packet of text messages to the jury for them to read by themselves, and they're not actually read into the record. But let's have a look at some of these text messages. They're interesting. Excited utterances. Where do we start? All right. So, in a case at bar, starting on November 13th, 2022 at 2:10, DM sends a text message to EG, who's the Uber driver. So this is 2:10. All right, so Kaylee and Maddie, they got home, correct me if I'm wrong, wasn't it just before 2 that they got home? Anyway, to inquire if he is driving. I'm going to have to check. Was it just before 2 they got home? Wasn't just before 3, was it? It was just before 2, I'm sure. I can't remember. Excited utterances. I know, it's hilarious. All right, sends a text message to the Uber driver to inquire if he's driving. The state submits this text message exchange is not hearsay because it will not be offered for the truth of the matter. Instead, it will be offered to show a timeline for the night. DM was awake and texting at 2:10. From 4:19 to 4:21, so 2 minutes, DM attempts to call BF, Xana, Kaylee, and Maddie. All calls unanswered. So these guys are already dead. She's probably asleep. Just before 2. It was just a shade before 2. So I'm glad other people in the chat are remembering it as I was. All right, so the records of these calls are not hearsay, as they each do not meet the definition statement. All right, they're not hearsay. Just recording the times of these is not hearsay. From 4:22 to 4:24, DM and BF send the following text messages. So DM, no one is answering. I'm really confused. What does RN mean? Oh, right now. I'm really confused right now. DM to Kaylee. Kaylee, what's going on? BF. So this is between 4:22 and 4:24. So 2 minutes. All of these are sent in 2 minutes. Bethany. Yeah, dude. WTF. Xana was wearing all black. Okay. DM. I'm freaking out right now. No, it's like a ski mask almost. Bethany. Shut the fuck up, actually. DM. Like he had something over his head and little and mouth. I'm not kidding. I'm so freaked out. Bethany, so am I. DM, my phone is going to die. Fuck. I'll plug it in then. Bethany, come to my room. Run down here. So Dylan actually was scared. She's seen someone. She's not sure what she's seen. Bethany tells her to shut the fuck up. But come to my room. Okay. So I don't see that these are negative. I don't see that they're negative for the defense necessarily. And they're not negative to the state, honestly. This is, you know, both of them are awake now. Maybe Bethany was awakened by the phone. And maybe she's pissed off. Shut the fuck up. Okay. All of the above declarations are present tense impressions and excited utterances. This is supported by DM's grand jury testimony, where she indicates she just witnessed a startling event, heard noises in residence, saw an unknown male in residence. Okay, trying to make sense of the startling events. Yeah, I agree. At 4:24, DM calls Ethan. Call unanswered because he's already dead. This phone record, like the other records of calls, is not a statement pursuant to blah, blah, blah. DM and BF continue to text. At 4:24, DM texts, what? I'm scared though. I'm scared though. And BF responds at 4:25, yeah, I know, but it's better than being alone. Again, both statements are admissible as present tense impressions and excited utterances. 4:27, DM calls Kaylee. 4:28, calls Xana. 4:32, sends a text message to Kaylee saying, please answer. The next morning, so did she go to Bethany's room or not? Maybe she did, maybe she didn't, I don't know. But the next morning, she sends the following text message at 10:23. So to Kaylee, please answer. Maddie, are you up? Kaylee, are you up? These text messages are not here, say, blah, blah, blah. 11:39. She has a text exchange with her dad, BM. These statements are not hearsay. 11:50. Receives the text messages from Jay stating bro. This text messages will not be included, all right, for the truth. 11:50. DM calls EA. This phone record is not. All right, so DM and BF. State anticipates that both DM and BF will testify at trial. The state intends to ask each witness about statements made to them on November 13th. The testimony should substantially replicate the testimony they provided at the grand jury proceedings. The state submits the statements from both DM and BF to each other are allowable hearsay because they are present sense impressions and excited utterances. Of course they are. There should be screwed, not scared. No, it's scared. It's not screwed, it's scared. Where was it? Where was it? I don't find it. Oh, there. I'm scared. Not screwed, scared. It's not got, it's not got the right number of letters for screwed. So she's got the R instead of A, and then W instead of E, which are near each other on the keyboard. So no, it's scared. I'm scared though. Yeah, I know, but it's better than being alone. It's not screwed, it's scared. The W, look at your keyboard right now. Look at your keyboard right now. The W is next to the E. That's scared. Not screwed. You're missing two E's out for screwed. Scared. It's the right number of letters. And you've got the R is near the A, and you've got the E is right next to the W. You've just got somebody texting, like probably worse for wear, in the middle of the night, making words up. I guess people who think that DM's a suspect are going to read it as screwed. Actually, it says scared. Okay. All right, where were we? In my humble opinion, of course, I wasn't there. All right. Judge John Judge has previously ruled that the text messages and statements of DM and BF are present tense. Okay, so if Judge Judge has already ruled on it, why are we bringing it up again? Why are we even bringing it up again? Exemptions of the hearsay rule. I guess they're just making sure that they're not going to get sideswiped. Maybe. DM's phone records, BF's testimony, any conclusion. Based on the above cited authority, the state respectfully requests the court's approval in limine of the admission of text messages. All right, I would grant that. I would say, yes, that's fine. Judge John Judge has previously said it's fine, so there's no reason why Hippler is going to say anything else. So, all right, those are the text messages. I don't think they're terribly problematic for either side, honestly. I think they're interested. But I don't know why they're incredibly controversial. Yeah, I'm scared though. So in context, like Bethany's saying, come down to my room then. Dylan says, I'm scared though. And Bethany replies, yeah, but it's better than being alone. It's context, isn't it? As well as the right number of letters, and the letters that are wrong are right next to the letters that should have been written. But then again, if you think Dylan's a suspect, you're going to read Screwed. Screwed that 4 people are dead. So, all right, guys. I'm going to go. I think I've covered everything I want to cover. If there's anything that you specifically want me to go into more detail on, let me know in the comments. If you're the replay crew, you'll be in the comments anyway. But let me know. Let me know if you would like me to go through any of these that I haven't covered. There's laws that I haven't covered. 911 call I've not covered. ATT timings I've not covered. Yeah, I did that one, didn't I? I did that one earlier. But if there's anything you want me to go in any more detail, I'll either do another live stream or I'll do it as a standalone video, as a recorded video. All right, so thank you all for joining me. And thank you, as always, to the mods. Did I have any donations that I've missed? No, I didn't. No donations. So no one to thank. That's all right. All right, enjoy the rest of your day, and I'll see you soon. Bye, guys.